Hello everyone, this is Robert Mansour, and I wanted to present a very quick explanation today of the standard estate plan that most of my clients implement. And you'll notice that in the background of this graphic I have a toolbox, a graphic of a toolbox, and that is the analogy that I like to use, that an estate plan is a legal toolbox, and it's full of all different kinds of legal tools that can help you and your family if something should happen to you, either death or incapacity or car accident or something that happens where people need to assist you. And also this assists in the distribution of property after you pass away. So the four major tools of the estate plan are on the screen. There's the living trust, which is at the top left, the wills, power of attorney, and healthcare documents. Now, there are other tools, but for our purposes today, we're going to hit on the big four. So a living trust is a legal document up here at the top left that an individual can create, two people can create, like a husband and a wife, and, three or four people. It depends. And the people who create the living trust are called the settlors. You'll see at the very top left the word settlor or settlors. If it's an individual, obviously settlor. Settlors for plural when you have more than one individual. And the term that you might be familiar with is grantor, trustor. They all mean the same thing. The settlors are the people who create the living trust, who create it from the very beginning. So an individual would be that person, a husband and wife, etc. Now, what I want you to understand also is that a living trust is basically a contract. It's a legally enforceable document. So the contents of the document can be enforced in court. So it's not anything terribly mysterious. For example, my wife and I have a living trust, and it is nothing more than a contract between me and my wife about what happens with our stuff if we should get sick, something happens to us, who is in charge. After we pass away, where does our estate go? And, who sees to it that those assets get to the right people? In our case, it's our two children. And we want to make sure that those assets get to our kids in a certain fashion. And all of those rules and regulations are contained in our living trust. Now, the next people involved in a living trust are called the trustees, right over here. These are the people who are in charge of everything that is in the living trust. So let's say, for example, let's say the Smith family creates the Smith Family Trust. Well, assets that are in the name of the Smith Family Trust are managed by the trustees. And in the very beginning, the trustees are the people who created the trust, whether it's an individual or a married couple. And so you are the initial trustee of your own trust. At some point, you will not be able to be the trustee, and the people who will take over are folks called your successor trustees. I use the analogy of the airplane, as you can see at the very top of the graphic here. In the very front of the airplane in the cockpit are the initial trustees, the husband and the wife, the individual who creates the living trust. The settlors are typically also the initial trustees. And in the first class of the airplane are the successor trustees. They're sitting there having champagne, maybe some shrimp cocktail. As soon as the people in the cockpit can no longer fly that plane, those successor trustees step into the cockpit and take control over the living trust. Now, they have to follow the flight plan, which is the rules of the living trust, so they can't just do anything they want. These stars here in the middle of the graphic, the stars, represent the assets of the living trust, the cargo on the plane, if you will. So a lot of people create a living trust, but they don't put anything in it. It's basically like building a house and not furnishing it. So once you create your living trust, you have to put things in your living trust, and you do that by changing title to your assets. So, for example, your real estate will no longer be held in your name alone. It would say Smith Family Trust on it, or, Johnson Family Trust. Your bank accounts, your investment accounts, not all of them, but many of them are going to say Smith Family Trust on them. And you have to actually physically go to the bank or to call your investment company and change the name on your assets once you create your living trust. We call that funding the living trust. Then the final people involved in the living trust are the beneficiaries. These are the people who benefit from the living trust. And once again, in the very beginning, it's the settlors, The people who created the living trust are the beneficiaries of their trust. And eventually, someday, other people will be the beneficiaries, such as the children or whoever else you have as the beneficiary of your living trust. Now, you'll notice out here there is a star that is floating out here. This is an asset that's not in the living trust. And I'll get to that in just a minute. Now, the living trust is a common document among two people or a single document among one person. And then you have the wills. If you're dealing with a married couple, each person is going to have their own will. And the person in charge of the will is called the executor. Executor. People tend to confuse the term executor and trustee a lot. They tend to use them interchangeably when in fact they are not interchangeable terms. They are separate jobs. Now, you can choose the same people to do those jobs, but they are separate jobs nevertheless. So the executor is the person in charge of the will, and the trustees are the people in charge of the trust. Now, you will notice that I put a trampoline down here, and here's why. I deliberately put the will under the living trust for the following reason. I want you to get a visual. The will is like a big safety net that sits under the trust. If an asset is sitting outside the trust, like this one over here, and after you die, we find this asset not in the trust, it falls, bounces off the trampoline, and goes into the trust. So consider the will like a big safety net that sits under your living trust. Now, you're also going to have powers of attorney. The power of attorney is also a very important document. The power of attorney is managed by somebody known as your agent. Your agent is the person who's in charge. Now, the agent can once again be the same people as the trustees, the executor. It can be the same people. It's just a different job. In most cases, a married couple, the husband is first in line for the wife, and the wife is first in line for the husband in most cases. So the agent is the person who gets to act on your behalf. So that's what the power of attorney is. You're giving someone the legal authority to act on your behalf in matters that do not directly involve your trust, your will, or healthcare decisions. So, for example, let's say I need to call my wife's credit card company or my wife's former employer because I need information about something. Sometimes you'll run into resistance when you do that because they'll tell you, no, we can't give you that information because it's private information. However, if I have power of attorney given to me by my wife to me, and I'm her agent, therefore I can act on her behalf. And there may be times in life when I need to do that. Now, keep in mind, this is a power that you have to give somebody. They can't take it from you. I get calls from clients all the time, and they say, hey, I'm at the hospital. My dad is sick. My mom is sick. I need power of attorney over them. I say, well, you can't just take it from them. They have to give you that authority. And in many cases, clients are calling me too late. Their father or their mother or their loved one is in a coma, or they are not doing well and they're at the hospital, whatever the case may be. So you want to make sure you get this legal toolbox set up before something happens. So that's power of attorney. And then you have the healthcare documents down here. Once again, we use the term agent to be the person in charge of healthcare decisions. There are two important documents in California that go under the healthcare discussion. The first one is something called an Advance Healthcare Directive. Sometimes people confuse this with something called power of attorney for healthcare. In California now, we call this thing an Advance Healthcare Directive, where you give someone the authority to make healthcare decisions on your behalf. Very similar to power of attorney up in the right here, but this one is specific to healthcare. And this is where you let people know what your wishes are. You know, what kind of measures do you want if you're very sick? And this is not just about pulling the plug. You know, that's what people usually think about. It's a lot more than that. This individual is your advocate. They are the ones who can demand answers from doctors and nurses and other professionals. They can move you from one facility to another. They can do a lot of things. It's not just about end-of-life decisions. And now in California, it's becoming increasingly important to have a separate authorization for the release of medical records. So even though you are the agent, some facilities might give you a hard time if you're trying to obtain the medical records of a loved one. And there may be times when you need those records for a variety of reasons, including perhaps getting a second opinion about a recommended surgery or something like that. So those are the documents that go into healthcare decisions. So this is just a very cursory and quick glance of the 4 major tools that go into most estate plans. I hope you found it helpful. If you want to learn more about my practice, you can always visit www.mansourlaw.com. And you can also call our office at 661-414-7100. Thanks so much.